I woke up to find an envelope wedged in my front door that would kick off the most ridiculous 3 months of my life in suburban Georgia. The return address read Willow Creek Homeowners Association, and my stomach immediately tightened. Nothing good ever came from those people. I ripped it open while standing on my porch in nothing but sweatpants, and there it was. A $500 fine for unauthorized placement of propane equipment in violation of community aesthetic standards. My name is Harold Hutchinson, and I had just installed a propane tank for my new backup generator exactly where the state inspector told me to put it. The placement wasn't random or careless. I had spent weeks getting permits from the state of Georgia, working with licensed contractors, and following every regulation down to the letter. The propane company had been explicit about where the tank needed to go for safety reasons, and the state inspector had signed off on everything. But apparently, none of that mattered to the Willow Creek HOA. I read the notice 3 times, each pass making my blood pressure rise another notch. The fine cited Section 7.3 of the HOA covenant, which I vaguely remembered being something about visual harmony and maintaining property values. According to their letter, my propane tank was visible from the street and created an industrial eyesore that violated community standards. They demanded I relocate it within 30 days or face additional fines of $100 per day. The thing was, I had checked those covenants before installing anything. I had read through the entire 40-page document twice, highlighting everything that might be relevant. There were rules about fence heights, paint colors, and lawn maintenance, but nothing specifically prohibiting propane tanks. The only mention of utilities was a vague statement about keeping external equipment reasonably concealed where practical. My tank was behind a decorative screen and partially hidden by landscaping. It was about as concealed as a 400-gallon propane tank could be without burying it underground, which the inspector had specifically told me not to do because of Georgia's clay soil and water table issues. I went inside and pulled out my permit folder, which had grown thick with documentation over the past 2 months. Installing the backup generator had been a priority after last year's ice storm knocked out power to our neighborhood for 5 days. My wife Sarah had been 7 months pregnant at the time, and we had spent those freezing nights at her mother's house 30 miles away. I had promised myself we would never be in that situation again. Now our daughter Emma was 8 months old, and I had finally gotten around to making good on that promise. The state permit was crystal clear. It showed the exact placement of the tank, approved by a licensed engineer and stamped by the Georgia Department of Community Affairs. There were specific safety requirements about distance from the house, clearance from property lines, and accessibility for delivery trucks. Every box had been checked. Every regulation had been met. The inspector had even complimented me on how thoroughly I had documented everything. I grabbed my phone and called the number on the HOA notice. A woman answered on the 3rd ring with a tone that suggested I had already inconvenienced her. Willow Creek, HOA. This is Brenda speaking. Hi, this is Harold Hutchinson on Maple Drive. I just received a fine about my propane tank, and I think there might be some confusion. No confusion, Mr. Hutchinson. Your tank violates our aesthetic standards. The fine stands. Her dismissiveness immediately got under my skin. I have a state permit that specifically approves the placement. The inspector signed off on everything. State permits don't override HOA covenants, Brenda said, her voice taking on that particular smugness that HOA board members seem to develop naturally. You agreed to follow our rules when you purchased your home, but there's no specific rule about propane tanks in the covenants. I checked. Section 7.3 covers all external equipment and structures. The board has determined your tank violates our standards. You have 30 days to relocate it, or the daily fines begin. I felt my jaw clenching. Can I appeal this to the board? You can submit a written appeal, but I should inform you that the board's decision in these matters is final. The next meeting is in 3 weeks. She gave me an email address and hung up before I could ask any more questions. I stood there holding my phone, trying to process the absurdity of the situation. I had done everything right, followed every rule, gotten every approval, and now some HOA board thought they could override state safety regulations because my tank didn't match their vision of suburban perfection. Sarah came downstairs carrying Emma, who was babbling happily and reaching for everything in sight. "What's wrong? You look like you're about to punch something." I handed her the letter. She read it while bouncing Emma on her hip, her expression shifting from confusion to anger. "This is ridiculous. You spent months getting that permit. Apparently that doesn't matter. The HOA thinks they can override state regulations. Can they? I don't know, but I'm going to find out." I spent the rest of the morning researching Georgia HOA law. The legal landscape was more complicated than I expected. HOAs in Georgia did have considerable power to enforce their covenants, but those covenants couldn't violate state or federal law. The question was whether my state permit gave me immunity from HOA regulations. The answer seemed to be maybe, depending on how a judge interpreted the conflict between state safety regulations and private covenant enforcement. I found a legal precedent from a case in Cobb County, where a homeowner had successfully challenged an HOA fine over a satellite dish. The FCC had rules protecting homeowners' rights to install satellite equipment, and the court had ruled that federal regulations superseded HOA restrictions. But propane tanks weren't exactly the same situation. There wasn't a specific federal law protecting them, just state safety regulations that required certain placement standards. The more I read, the more I realized I was in for a fight. I could pay the fine and move the tank, but that would mean violating my state permit and potentially creating a safety hazard. The inspector had been clear that the current location was the only spot on my property that met all the safety requirements. Moving it closer to the house or property lines could put my family at risk, and I would probably lose my permit entirely. I decided to write a detailed appeal to the HOA board, documenting everything. I spent 3 hours that afternoon crafting a letter that explained the permitting process, the safety requirements, and the legal authority of state regulations. I attached copies of my permits, the engineer's drawings, the inspector's report, and the relevant sections of Georgia code. I made the letter as professional and non-confrontational as possible, thinking that maybe if I just explained the situation clearly, reasonable people would back down. I was incredibly naive. The response came back 5 days later. Not from the full board, but from someone named Margaret Anderson, who identified herself as the HOA president. Her email was 3 paragraphs of condescension wrapped in corporate politeness. She thanked me for my concerns, but reiterated that state permits did not grant exemptions from HOA covenants. She suggested I contact my propane company about relocating the tank to a more appropriate location. She ended by reminding me that the 30-day deadline was still in effect, and failure to comply would result in daily fines plus the possibility of legal action to force compliance. I read the email twice, then called the propane company. The technician I spoke with listened to my situation and let out a long sigh. "Yeah, we get this sometimes. HOAs don't understand that these tanks can't just go anywhere. Your current location is the only spot that meets code. If we move it, you'll be out of compliance with your state permit, and we could lose our license for doing an installation that violates safety regulations. So what do I do? Get a lawyer, probably. We've had customers fight this before. Sometimes they win, sometimes they don't. But we can't move the tank to a location that violates state code. That's non-negotiable. I thanked him and hung up, feeling the weight of the situation settling on my shoulders. This wasn't going to be resolved with polite letters and reasonable conversation. The HOA had drawn a line in the sand, and they clearly expected me to back down. I wasn't going to back down. Sarah and I talked about it that evening after putting Emma to bed. We sat at the kitchen table with our laptops open, looking at our finances and trying to figure out if we could afford a lawyer. "How much do you think this will cost?" Sarah asked. "I don't know. Could be a few thousand. Could be more if it goes to court. And if we just pay the fine and move the tank? Then we're violating the state permit, which could mean fines from the state, possible safety hazards, and we'd have to go through the whole permitting process again. Plus, there's no guarantee we could even get a new permit for a different location. The inspector was pretty clear that the current spot is the only one that works." Sarah rubbed her temples. "So we're stuck between the HOA and the state. Pretty much. This is insane." "You followed all the rules." "I know. We decided to at least consult with a lawyer before making any decisions. I found a local attorney who specialized in HOA disputes and made an appointment for the following week. In the meantime, I started documenting everything. I took photographs of the tank installation from every angle, showing how it was partially screened and not really the eyesore the HOA claimed. I printed out every email, every permit, and every inspection report. I even went through the HOA covenants again with a highlighter, marking every section that might be relevant. The more I dug into those covenants, the more problems I found with the HOA's position. Section 7.3 did mention external equipment, but the language was vague and focused on things like air conditioning units and pool equipment. There was nothing about propane tanks or backup generators. More importantly, there was a clause in Section 1.8 that stated the covenants were subject to all applicable federal, state, and local laws and regulations. That seemed like it should settle the matter. My state permit was issued under Georgia law, which should take precedence over private covenants, but HOAs have a way of twisting language to serve their purposes. I had lived in Willow Creek for 4 years, and I had seen them fine people for the most ridiculous things. A neighbor 3 houses down had been fined for having the wrong shade of white paint on his shutters. Another family had been threatened with legal action because their teenage son's basketball hoop was 6 inches over the height limit. The HOA board ran the neighborhood like their personal fiefdom, and they didn't like being challenged. The lawyer consultation didn't fill me with confidence. James Morrison was a pleasant man in his 50s who had handled dozens of HOA cases. He listened to my situation, reviewed my documents, and gave me the kind of honest assessment that lawyers give when they're not just trying to take your money. "You have a strong case," he said. "The state permit gives you solid legal ground, but HOAs are unpredictable. They have their own lawyers, and they're often willing to spend association money fighting these battles. Even if you're right, it could take months and cost thousands of dollars. What do you think my chances are in front of a judge? Probably 80% in your favor. But getting in front of a judge takes time. First, you have to exhaust the HOA's internal appeals process. Then they might try to take you to their arbitration process, which is usually biased toward the HOA. If you refuse arbitration, they could file a lawsuit to enforce the fine. then you'd have to defend yourself or countersue. It's a process. How much are we talking? My retainer is $3,000. If it goes to actual litigation, probably another $5,000 to $10,000 depending on how long it drags out. Could be more if they really dig in. I felt my heart sink. We didn't have that kind of money just sitting around. We had savings, but that was for Emma's future and emergencies. Fighting an HOA over a propane tank hadn't been in our financial planning. What if I just represent myself? Morrison gave me a sympathetic look. You could try. Some people do. But HOAs have lawyers who do this all day, every day. They know the tricks, the procedural moves, the ways to drag things out and make it expensive and exhausting. Representing yourself against that is like bringing a knife to a gunfight. I left his office feeling defeated. Sarah and I talked about it for days, weighing our options. The 30-day deadline was approaching. I tried one more time to reason with the HOA, sending another email to Margaret Anderson explaining the legal situation and asking for a compromise. Maybe they could approve a variance, or we could plant more landscaping to further screen the tank. Her response was short and final. The board has made its decision. Comply with the notice or face the consequences. That was when I realized this wasn't really about the propane tank. This was about power and control. Margaret Anderson and her board didn't like being told they were wrong, and they especially didn't like state regulations interfering with their authority. They were willing to waste association money and my time to prove a point. I decided to fight. I filed my formal appeal with the HOA board, requesting an appearance at their next meeting. I prepared a presentation with photographs, permit documents, and printed excerpts from Georgia Code. I practiced explaining the safety requirements and why the tank had to be where it was. I was going to make them look me in the eye and tell me that their aesthetic preferences were more important than state safety regulations. The board meeting was held in the community center at the entrance to our neighborhood. It was a Tuesday evening, and about 20 homeowners were scattered around the room when I arrived. Most of them were there for other issues, bored-looking people waiting for their turn to discuss parking violations or request approval for new mailbox designs. The board sat at a table at the front of the room. Margaret Anderson was in the center, a woman in her mid-50s with perfectly styled blonde hair and the kind of expensive casual outfit that screamed, "I volunteer because I'm bored." Flanking her were 4 other board members, 2 men and 2 women, all of a similar age and disposition. They looked like they would be more comfortable at a country club than running a neighborhood association. Margaret called the meeting to order and worked through the agenda with brisk efficiency. She approved a fence variance, denied a request to install a shed, and lectured a young couple about their overflowing garbage cans. Each item took about 5 minutes, and I watched the board members nod along with Margaret's pronouncements like bobbleheads on a dashboard. Finally, she got to my item. Next, we have an appeal from Harold Hutchinson regarding a fine for unauthorized propane tank placement. Mr. Hutchinson, you have 5 minutes to present your appeal. I stood up, feeling every eye in the room turn toward me. I walked to the front with my folder of documents and began my presentation. I explained the permitting process, showed them the state inspector's approval, and walked through the safety requirements that dictated the tank's placement. I pointed out the section in the covenants that subordinated HOA rules to state law. I kept my tone respectful but firm, making it clear that I had followed every rule and that their fine was not only unjust, but potentially dangerous. Margaret listened with an expression that suggested she was tolerating an annoying child. When I finished, she didn't even look at my documents. "Mr. Hutchinson, we appreciate your concerns, but the board's position remains unchanged." The state permit process is separate from HOA covenant enforcement. You agreed to follow our rules when you moved here, and those rules exist to maintain property values for everyone in the community. Your propane tank is visible from the street and creates an industrial appearance that is inconsistent with our neighborhood character. But the state regulations require it to be there, I said, trying to keep my frustration out of my voice. Moving it would violate safety codes. Then perhaps a backup generator isn't appropriate for your property, Margaret said smoothly. Many homeowners manage perfectly well without them. We lost power for 5 days during last year's ice storm. My wife was pregnant. This isn't about convenience, it's about safety. That's a personal choice, Mr. Hutchinson. The HOA cannot make exceptions based on individual circumstances. If we allowed every homeowner to violate our aesthetic standards for personal reasons, the neighborhood would descend into chaos. One of the other board members, a man named Richard, leaned forward. Have you considered moving the tank to the back of your property? Behind your garage? The inspector specifically ruled that out. It's too close to the property line and doesn't have adequate clearance from the neighbor's fence. It would violate state code. Well, those seem like problems you need to solve, Margaret said. The board's decision stands. You have 2 weeks remaining to relocate the tank or the daily fines will begin. This matter is closed. This isn't legal, I said, my voice rising despite my best efforts. You can't override state safety regulations. We're not overriding anything. We're enforcing our covenants, which is our legal right and responsibility. If you believe otherwise, you're welcome to seek legal counsel. But I suggest you'll find that the courts support HOA authority in these matters. She moved on to the next agenda item without another word. I stood there for a moment, feeling the anger and frustration bubbling up inside me. The other homeowners were looking at me with a mixture of sympathy and discomfort. I wanted to argue more, to make Margaret and her board understand how wrong they were, but I knew it would be pointless. I gathered my documents and walked out of the community center into the cool November evening. Sarah was waiting up when I got home. One look at my face told her how it went. They didn't care, I said, dropping my folder on the kitchen counter. They didn't even look at my documents. Margaret made it clear that they don't care about state permits or safety regulations. This is about power. So what do we do? I don't know. I'm not moving the tank. It's not safe and it would violate my permit, but if I don't move it, they're going to start hitting us with daily fines. Can they really do that? Apparently. And if we don't pay, they can put a lien on the house. Sarah sat down, looking exhausted. This is insane. How is this legal? Because HOAs in Georgia have a ridiculous amount of power. They can pretty much do whatever they want as long as it's in their covenants, and those covenants are so vague they can interpret them however they like. We sat there in silence for a while, the weight of the situation pressing down on us. Finally, Sarah said, "We need to find a different lawyer, someone who will fight this." She was right. James Morrison had been honest but unenthusiastic. We needed someone who would be aggressive, who would take the fight to the HOA instead of just defending us. I spent the next few days researching lawyers who specialized in challenging HOAs, not just negotiating with them. I found a firm in Atlanta that had a reputation for taking on HOA boards and winning. The attorney's name was David Chen, and his initial phone consultation was completely different from Morrison's measured pessimism. Chen listened to my situation and immediately got excited. "This is exactly the kind of case that needs to be fought," he said. "HOAs have gotten way too comfortable pushing people around. You have a state permit issued under regulatory authority. That's not just a suggestion, it's the law. The HOA can't override state safety regulations with their aesthetic preferences." The previous lawyer I talked to said it could be expensive and take months. It might be, but this is also the kind of case that could set a precedent. If you're willing to fight, I'm willing to take this on. My firm handles these cases on a modified contingency basis for the right clients. You pay a reduced retainer, and if we win, we go after the HOA for attorney's fees. Can you do that? Georgia law allows for fee recovery in HOA disputes when the HOA is acting unreasonably. And trust me, this is unreasonable. They're essentially telling you to violate state safety code to satisfy their aesthetic whims. A judge is going to hate that. For the first time since this mess started, I felt a spark of hope. Chen's confidence was infectious, and his approach was exactly what I needed. We agreed to meet in person to go over everything in detail. The meeting with Chen was thorough and encouraging. He reviewed all my documents, asked detailed questions about the permit process, and even called the state inspector's office to verify the information I had provided. Everything checked out. Chen's strategy was straightforward. File a declaratory judgment action asking the court to rule that my state permit superseded the HOA's covenants, and simultaneously ask for an injunction preventing the HOA from enforcing their fines while the case was pending. This is going to make them angry, Chen warned. HOAs don't like being challenged in court. They might try to escalate, maybe go after you for other violations or make life difficult in other ways. You need to be prepared for that. I'm prepared. I'm done being reasonable with these people. Chen grinned. Good, because we're about to make their lives very uncomfortable. He filed the lawsuit the following week. The complaint was a beautiful piece of legal writing that systematically demolished the HOA's position. It cited Georgia statutes on residential construction and safety, explained the regulatory authority behind my permit, and pointed out that the HOA's covenant subordination clause meant they had already agreed to defer to state law. It also included a request for attorney's fees and damages for the stress and expense the HOA had caused. The reaction was immediate and predictable. Margaret Anderson called me 2 days after the lawsuit was filed, her voice tight with anger. Mr. Hutchinson, I've been informed that you filed a lawsuit against the association. I want you to know that this is completely unnecessary and will only result in significant legal expenses for you. You gave me no choice. I tried to work with you. I showed you the permits and explained the safety issues. You refused to even consider the facts. The board made a reasonable decision based on our covenants. You're wasting everyone's time and money with this frivolous lawsuit. It's not frivolous. You're trying to force me to violate state safety regulations. We're doing no such thing. We're simply enforcing our rules. If you can't comply, you shouldn't have installed the tank. I have a state permit that says otherwise. We'll see what the court says about that. I hope you have deep pockets, Mr. Hutchinson. This association will not be bullied by selfish homeowners who think they are above the rules. She hung up before I could respond. The irony of her calling me selfish while using association funds to fight a losing legal battle was apparently lost on her. The next HOA newsletter was particularly vicious. There was a section titled Legal Updates that didn't mention me by name but made it very clear what they were talking about. It described a homeowner who had chosen to sue the association rather than work collaboratively to resolve a minor violation, and warned that legal costs would be recovered from the responsible party when the association prevails. The newsletter framed the whole situation as an attack on the community, suggesting that my lawsuit was costing every homeowner money and threatening the stability of the neighborhood. I started getting cold shoulders from some neighbors. A few people I had been friendly with suddenly found reasons to avoid me. Others were more direct. Tom Henderson, who lived 2 doors down, stopped me while I was checking my mailbox one afternoon. "Hey, Harold, what's this about you suing the HOA? They fined me for my propane tank even though I have a state permit for it." "Yeah, but now the association has to spend money defending your lawsuit. That comes out of everyone's dues. They could drop the fine. I tried to work with them. Margaret says you didn't even try to compromise." "That's not true. I offered multiple solutions. She refused to budge." Tom shrugged. "I don't know, man. Seems like you could just move the tank and avoid all this drama." "I can't move it without violating state safety code." "Well, I hope you know what you're doing." "A lot of people are pretty upset about this." He walked away before I could explain further. That was the pattern for the next few weeks. The HOA had successfully framed me as the villain, the troublemaker causing problems for everyone else. Never mind that they were the ones being unreasonable. Never mind that I had followed every rule and obtained every permit. In the court of neighborhood opinion, I was losing. Sarah noticed the change too. One of her friends from the neighborhood book club suddenly stopped responding to texts. Another made an awkward comment about hoping things get resolved soon, with a tone that suggested it was my fault things weren't resolved already. "They're turning everyone against us," Sarah said one evening. "Margaret is telling everyone her version of the story, and nobody's asking for ours. Let them think what they want. We're right and the court will prove it." "I know, but it still sucks. I have to live in this neighborhood. Emma will grow up here. I don't want everyone thinking we're the bad guys." I didn't have a good answer for that. The social pressure was real, and it was starting to wear on both of us. But backing down now would mean admitting defeat and probably still dealing with the HOA's fines. We were committed to seeing this through. Chen called a few weeks later with an update. The HOA's lawyer filed their response. "It's pretty much what I expected. They're arguing covenant enforcement authority and claiming your permit doesn't give you immunity from private contractual obligations. But here's the interesting part. They're also arguing that you could have designed your generator system differently to avoid needing the propane tank in that location. That's not true. The inspector approved this design specifically because it was the only safe option." "I know. And we're going to prove that. I've scheduled a deposition with the state inspector who approved your permit. Once we get his testimony on record about why the tank has to be where it is, the HOA's argument falls apart." The deposition took place in Chen's office on a cold morning in early December. The state inspector, whose name was Robert Mills, was a no-nonsense man in his 60s who had been doing safety inspections for 20 years. He sat across from the HOA's attorney, a sharp-dressed woman named Patricia Coleman, and answered questions about the permitting process. Coleman tried to suggest that there were other possible locations for the tank, but Mills shut that down immediately. "No, there weren't. I evaluated the entire property. The current location is the only spot that meets minimum clearance requirements from the structure, property lines, and other hazards. Moving it anywhere else would violate state code." "But surely there are ways to design around those restrictions," Coleman pressed. "Not on that property. It's a standard suburban lot with minimal setbacks. The house placement, garage, and property boundaries create natural constraints. The applicant and his contractor actually did an excellent job working within those constraints. This is a textbook example of proper installation." "What about underground installation?" "Not feasible. The soil conditions and water table make underground tanks problematic. We generally don't approve them in that area unless there's absolutely no other option. And even if we did, it would cost 3 times as much. You can't force someone to spend tens of thousands of extra dollars for underground installation just because of aesthetic preferences. Coleman tried a few more angles, but Mills had an answer for everything. His testimony was clear and unambiguous. My tank was exactly where it needed to be, and moving it would violate state safety regulations. Chen was grinning by the time the deposition ended. "That's going to be very hard for them to overcome," he said after Coleman left. "We've got a state inspector on record saying your installation is proper and safe. The HOA is arguing aesthetics against safety. No judge is going to side with them. So, what happens next? We have a hearing scheduled in January for the preliminary injunction. If we win that, the HOA can't enforce their fines while the case is pending. Then we move toward trial, but honestly, I think they'll settle once they lose the injunction hearing. Their lawyer has to know they're on shaky ground." The holidays passed in a strange fog. Sarah and I tried to focus on Emma's first Christmas, but the lawsuit hung over everything. I kept getting updates from Chen about filings and motions, legal maneuvering that I only partly understood. The HOA had started sending me notices about other supposed violations. My grass was a quarter-inch too long. My trash cans were visible from the street 15 minutes past the allowed time. My mailbox needed repainting. It was obvious harassment, but there wasn't much I could do about it except document everything and add it to the lawsuit. The preliminary injunction hearing was scheduled for January 15th. Chen was confident, but I was nervous. We were about to stand in front of a judge and ask him to override an HOA board's decision. Even with all our documentation and the inspector's testimony, there was no guarantee how it would go. Judges had broad discretion in these cases, and some were more sympathetic to HOA authority than others. The courthouse in Marietta was busy that morning. Chen met me outside, looking professional and calm in his suit and tie. We went through security and made our way to the assigned courtroom. The HOA's lawyer, Patricia Coleman, was already there, sitting at the defense table with Margaret Anderson beside her. Margaret gave me a cold stare as I entered. I ignored her and sat down next to Chen. Judge William Foster entered a few minutes later, a gray-haired man in his 60s who had a reputation for being fair but firm. He called the case, and Chen stood to present our argument. Chen was impressive to watch. He laid out the facts methodically, walking the judge through the permitting process, the state regulations, and the inspector's testimony. He explained why the tank had to be in its current location and why moving it would create safety hazards. He cited case law supporting the principle that state regulations supersede private covenants when there's a direct conflict. He painted the HOA's position as unreasonable and potentially dangerous. Coleman's counter-argument focused on the sanctity of HOA covenants and the importance of allowing associations to enforce their rules. She argued that state permits didn't grant blanket immunity from private contractual obligations, and that homeowners needed to consider HOA rules when planning improvements. She suggested that I should have sought HOA approval before installing the tank, and that my failure to do so showed I wasn't acting in good faith. Judge Foster listened to both sides, occasionally asking questions or requesting clarification. His expression was neutral, giving nothing away. After both lawyers finished, he leaned back in his chair and was quiet for a long moment. "Let me make sure I understand the situation," he finally said. "Mr. Hutchinson obtained all necessary state permits for this installation. A state inspector reviewed and approved the specific placement of this propane tank based on safety regulations. The HOA is now fining Mr. Hutchinson for that same placement, claiming it violates aesthetic standards in their covenants. Is that correct?" "Yes, Your Honor," both lawyers said. And Miss Coleman, you're arguing that Mr. Hutchinson should relocate the tank to satisfy the HOA, even though doing so would violate state safety codes. We're arguing that he had other options for designing his system that wouldn't have required placing the tank in a visible location, Your Honor. But the state inspector testified that the current location is the only one that meets safety requirements on this property. Correct. The inspector gave an opinion based on the system as designed. Alternative designs might have been possible. Might have been, Judge Foster repeated. That's speculative. What we have here is concrete, a state permit issued under regulatory authority that specifically approves this installation. The alternative you're proposing is speculative at best and would require violating an existing state permit at worst. He paused, looking at his notes. Here's my concern with the HOA's position. If I allow you to enforce this fine, I'm effectively ruling that aesthetic preferences in a private covenant can override state safety regulations. That seems like a dangerous precedent. State regulations exist for a reason, and they're issued by people with expertise in safety engineering. HOA boards, with all due respect, generally don't have that expertise. Margaret's face was turning red. I tried not to show any reaction, but I felt hope rising in my chest. I'm going to grant the preliminary injunction, Judge Foster said. The HOA is prohibited from enforcing fines related to the propane tank placement while this case is pending. Mr. Hutchinson has demonstrated a likelihood of success on the merits. The state permit appears to provide authorization that supersedes the HOA covenant restrictions in this specific instance. Coleman stood up quickly. Your Honor, we would like to request a stay of that order pending appeal. Denied. This isn't a complicated issue, Miss Coleman. Your client is trying to override state safety regulations with aesthetic rules. That's not going to fly in my courtroom. If you want to appeal my ruling, that's your right, but the injunction stands in the meantime. He banged his gavel, and just like that, it was over. Chen was grinning. Margaret looked like she had just swallowed something toxic. We walked out of the courtroom into the hallway, and I felt like I could finally breathe again. That went better than expected, Chen said. Judge Foster basically told them they're going to lose the full case. Most lawyers would advise their clients to settle at this point. Will they settle? Depends how stubborn the board is. Some HOAs would rather spend money fighting than admit they were wrong, but they're on notice now. If they keep pushing this, they're going to lose and end up paying your attorney's fees on top of their own. We walked out of the courthouse into the cold January air. I felt lighter than I had in months. The injunction wasn't a complete victory, but it was validation. A judge had looked at the facts and sided with me. The state permit did matter. Safety regulations did override HOA aesthetic rules. I had been right all along. I called Sarah from the parking lot to tell her the news. She actually cheered into the phone, a sound of pure relief. Does this mean it's over? Not quite, but we're close. The HOA might still push forward with the full trial, but Chen thinks they'll probably settle. I hope so. I'm so tired of this. Me too. The HOA newsletter that month didn't mention the hearing, but the tone had shifted slightly. The legal updates section now included language about the board carefully evaluating its options and considering the best interests of the community. Reading between the lines, it seemed like at least some board members were getting nervous about the cost and risk of continuing the fight. But Margaret Anderson wasn't ready to give up. I found out later that she had argued strongly for appealing Judge Foster's ruling, and while the board ultimately decided against an appeal, they did vote to continue with the full trial. According to one neighbor who attended the meeting, Margaret had given an impassioned speech about not letting rogue homeowners dictate terms to the association. She framed settling as surrender, and surrender was unacceptable. Chen filed a motion to expedite the trial, arguing that leaving the case hanging over my head while the injunction was in place wasn't fair to either party. The judge agreed, and trial was set for March. That gave us about 6 weeks to prepare. During that time, the harassment from the HOA intensified. I received violation notices almost weekly, each one more petty than the last. My house numbers needed to be repainted because they were faded, even though they were perfectly legible. My front lawn had some brown patches from winter weather, which apparently violated the lawn maintenance standards. My mailbox post was leaning, though I couldn't see any lean at all when I looked at it. Each notice threatened fines if the violation wasn't corrected within 10 days. Chen told me to document everything, but not to engage with the notices unless they actually tried to levy fines. They're trying to harass you into settling on their terms, he said. Don't let them get to you. Focus on the trial. I tried to follow his advice, but the constant notices were wearing. Sarah started bringing in the mail because she didn't want me to see another HOA letter and have my day ruined. We were both counting down to March, hoping that the trial would finally put an end to this nightmare. One afternoon in late February, I came home from work to find Margaret Anderson standing on my front porch. She was dressed in expensive athletic wear, like she had just come from a yoga class or tennis lesson. Her expression was a mixture of determination and condescension. "Mr. Hutchinson, I'd like to talk with you about resolving this situation." I should have just closed the door, but I was too surprised by her presence to react quickly. "What do you want?" "I want to offer you a compromise. The board has authorized me to propose a settlement." "I'm listening." "We'll withdraw the fine for the propane tank if you agree to pay the association's legal fees incurred so far and sign a waiver agreeing not to sue us for malicious prosecution or abuse of process. You can keep your tank where it is, and we'll all move forward." I stared at her, trying to process what she had just said. "You want me to pay your legal fees for a case you're losing?" "We're not losing anything. We're offering you a reasonable compromise." "That's not a compromise. That's you trying to stick me with the bill for your mistake." "The board spent considerable resources defending against your unnecessary lawsuit. You could have avoided all of this by just accepting that my state permit overrides your aesthetic rules, or by granting a variance, or by being reasonable in any way." Margaret's expression hardened. "The board will not be dictated to by individual homeowners who think they're special. We offered you a way out. If you refuse, we'll see you in court." "See you in court, then." She turned and walked away without another word. I went inside and immediately called Chen to tell him about the encounter. "They came to your house. That's inappropriate, and their settlement offer is laughable. They know they're losing and they're trying to get something out of you before it's too late. So we're definitely going to trial." "Looks like it, but don't worry. We're in a strong position. The judge already indicated he thinks you're going to win. This is just Margaret's ego at this point." The trial was scheduled for March 10th, a Tuesday morning. The week before, Chen and I spent hours preparing my testimony. He coached me on how to answer questions, how to stay calm under cross-examination, and what to expect from Coleman's strategy. We practiced until I could recite the timeline of my permit applications and the details of the inspector's requirements without hesitation. The night before trial, I barely slept. Sarah and I lay in bed talking about what might happen, running through best and worst case scenarios. Emma was restless too, sensing our tension and waking up twice before midnight. By the time morning came, I was exhausted and wired at the same time, running on coffee and nervous energy. The courtroom was smaller than I expected for a full trial, a modest wood-paneled room with space for maybe 30 people in the gallery. Chen and I sat at the plaintiff's table. Coleman and Margaret were at the defense table along with two other HOA board members, Richard and a woman named Susan. A few other homeowners from Willow Creek were scattered in the gallery, curious about how this would play out. Judge Foster entered promptly at 9, and the trial began. Chen gave his opening statement, outlining our case and explaining why the state permit should supersede the HOA covenant. Coleman gave her opening, arguing that HOA covenants were enforceable contracts and that state permits didn't give blanket immunity from private obligations. Then came the testimony. I was the first witness. Chen walked me through the entire story, why I wanted a backup generator, how I researched the requirements, the permitting process, the installation, and the HOA's fine. I explained how I had tried to work with the HOA board, offered compromises, and shown them the state regulations. Chen entered all my documents into evidence, the permits, the inspection reports, the emails, everything. Coleman's cross-examination was aggressive. She tried to suggest I had deliberately placed the tank in a visible location out of laziness or to save money. She questioned why I hadn't explored underground installation or alternative generator technologies. She implied that I had been uncooperative with the board and that I could have worked with them if I had really wanted to. I stayed calm and stuck to the facts. The inspector had approved this location as the only safe option. Underground installation wasn't feasible. I had offered multiple compromises, and the board had rejected all of them. The state permit was clear and unambiguous. Next came Robert Mills, the state inspector. Chen had subpoenaed him to testify in person, and his testimony was even stronger than his deposition. Mills explained the regulatory framework in detail, walked through why the tank had to be in its current location, and made it clear that moving it would violate state code. Coleman tried to shake him on cross-examination, but Mills was unflappable. He had done thousands of inspections, and he knew exactly what he was talking about. The HOA called Margaret Anderson as their witness. She testified about the board's concerns with neighborhood aesthetics, the importance of maintaining property values, and the need to enforce covenants consistently. She made it sound like I was being unreasonable for refusing to compromise, conveniently omitting all the times I had tried to compromise, and she had refused. Chen's cross-examination of Margaret was brutal. He pulled out emails where she had dismissed my concerns without consideration. He asked her if she had any expertise in propane safety regulations. He questioned whether any board member had consulted with an engineer or safety expert before issuing the fine. He got her to admit that the covenant section they were relying on didn't specifically mention propane tanks, and that the board had interpreted it broadly to fit their purposes. By the time Margaret stepped down, she looked rattled. The board's other witnesses were equally weak. Richard testified about the importance of neighborhood harmony, but couldn't explain why safety regulations should be ignored to achieve that harmony. Susan talked about property values, but admitted under cross-examination that she had no evidence my propane tank had actually affected anyone's property value. Closing arguments were scheduled for the next day. I spent that evening with Chen going over what to expect. He was confident but cautioned me not to celebrate yet. Trials are unpredictable, but I think we did well. The inspector's testimony was key. Coleman couldn't undermine it, and without that, their whole case falls apart. The next morning, Coleman gave her closing argument first. She emphasized the sanctity of private covenants, the need for HOA enforcement authority, and the importance of homeowners honoring their agreements. She argued that allowing my state permit to override the covenant would open the floodgates to other violations and undermine the entire concept of HOA governance. Chen's closing was methodical and powerful. He went through the evidence point by point, showing how the state permit was issued under regulatory authority that superseded private covenants. He emphasized the safety aspects, reminding the judge that this wasn't about aesthetics versus aesthetics, but about aesthetics versus safety. He cited the covenant's own subordination clause, which explicitly made HOA rules subject to state and federal law. He argued that the HOA had acted unreasonably by refusing to grant a variance or consider any compromise. Then he made his final point. Your Honor, this case is about more than just a propane tank. It's about whether HOA boards can use vague covenant language to override state safety regulations. If the answer is yes, then what's to stop an HOA from prohibiting fire escapes because they're ugly? Or emergency generators because they're noisy? Or wheelchair ramps because they don't match the neighborhood aesthetic? State regulations exist to protect people. HOA covenants exist to protect property values. When those two things conflict, the law has to protect people first. Judge Foster took a brief recess to consider his ruling. 20 minutes felt like 20 hours. Finally, he returned to the bench and began to speak. I've given careful consideration to the arguments and evidence presented. This case requires balancing two legitimate but competing interests: the authority of homeowner associations to enforce their covenants, and the authority of the state to regulate safety matters through the permitting process. He paused, looking at his notes. In this case, I find that the state's regulatory authority must prevail. Mr. Hutchinson obtained a valid permit from the state of Georgia for the installation of his propane tank. That permit was issued by a qualified inspector following established safety regulations. The inspector testified credibly that the tank's current location is the only one that meets state safety requirements on Mr. Hutchinson's property. Margaret's jaw was clenched tight. I tried to keep my expression neutral. The HOA's covenant does contain language about external equipment, but it's vague and doesn't specifically address propane tanks or backup generators. More importantly, Section 1.8 of the covenant explicitly states that all HOA rules are subject to applicable state and federal law. The HOA cannot use vague, aesthetic language to override specific state safety regulations. Furthermore, I find that the HOA acted unreasonably in this case. Mr. Hutchinson made multiple attempts to work with the board. He provided documentation, offered compromises, and explained the regulatory requirements. The board refused to consider any of this information and instead issued fines based on aesthetic preferences. That's an abuse of HOA authority. Judge Foster looked directly at Margaret. Miss Anderson, HOA boards serve an important function in maintaining neighborhood quality. But you're not above the law. When a state agency issues a permit following proper regulatory procedures, you can't simply override it because you don't like how something looks. He turned back to his written ruling. I find in favor of the plaintiff on all counts. The HOA's fine is void and unenforceable. Mr. Hutchinson is entitled to keep his propane tank in its current location. The HOA is ordered to remove any record of violations from Mr. Hutchinson's account. Chen squeezed my arm under the table, but Judge Foster wasn't done. Additionally, I find that the HOA acted unreasonably in pursuing this matter. Mr. Hutchinson is awarded attorney's fees and costs in the amount to be determined after the plaintiff submits proper documentation. The HOA is also ordered to pay damages in the amount of $500 for the stress and inconvenience caused by this frivolous enforcement action. He banged his gavel. We're adjourned. I sat there for a moment, letting it sink in. We had won, not just won, but won decisively. The judge had vindicated everything I had said. The state permit did override the HOA covenant. The board had acted unreasonably, and now they were going to pay for it. Chen was grinning broadly. That's about as complete a victory as you can get. Congratulations. Margaret stood up abruptly and walked out of the courtroom without looking at anyone. Coleman began gathering her papers with a resigned expression. The other board members looked shell-shocked. Several neighbors who had been in the gallery came over to congratulate me. One couple said they had been following the case closely and were thrilled I had won. An older man said the board had been out of control for years, and maybe this would make them think twice before harassing other homeowners. I thanked them and walked out of the courthouse with Chen. The March air was crisp and cool, and everything seemed brighter than it had that morning. "What happens now?" I asked. "We submit our fee documentation to the judge. Based on the time I've spent, we're looking at probably $12,000 to $15,000 in fees. The HOA will have to pay that plus their own legal costs. This was an expensive lesson for them. Will they appeal? They could, but they'd be crazy to. The judge's ruling was thorough and well-reasoned. An appeals court isn't going to overturn this. My guess is the board will cut their losses and move on." He was right. 2 weeks later, Coleman filed a notice that the HOA would not appeal. The board sent out a letter to all homeowners explaining that they had concluded the litigation regarding propane tank placement, and that, while the board maintains it acted properly in enforcing the covenants, we respect the court's decision and will not pursue further legal action. There was no apology, no acknowledgement that they had been wrong, just corporate language to save face. But it didn't matter. The legal battle was over, and I had won. The real victory came a month later when I received a check from the HOA's insurance company for attorney's fees and damages. Chen had submitted a detailed fee petition, and the judge had approved it in full. $13,800 in fees, plus the $500 in damages, plus court costs. The HOA's own legal bills were probably similar, meaning they had spent close to $30,000 fighting a losing battle over a propane tank. Sarah and I went out to dinner to celebrate, our first night out without Emma in months. We sat at a nice Italian restaurant in Marietta and toasted to surviving the craziest 6 months of our lives. "I can't believe it's actually over," Sarah said. "Me neither. I kept waiting for something else to go wrong." You think the board learned anything from this? Probably not. But at least other homeowners know they can fight back when the HOA is being unreasonable. We ordered too much food and didn't care. The weight that had been pressing down on us for months had finally lifted. I could park in my driveway without worrying that the HOA would measure how far my tires were from the curb. I could check the mail without dreading another violation notice. I could just be a normal person living in a house, which was all I had wanted in the first place. The neighborhood dynamics shifted after the trial. Some people, the ones who had supported Margaret and the board, still gave me cold shoulders, but others started asking questions about their own HOA disputes. A neighbor 3 streets over was fighting over solar panel placement and wanted to know about my lawyer. Another family was being fined for a vegetable garden and asked if I thought they had a case to fight it. Chen ended up taking on 2 more cases against the Willow Creek HOA in the following months. Both settled quickly once the board realized they were up against a lawyer who knew how to beat them. The culture of casual harassment and petty enforcement started to ease up. The board was more cautious about issuing fines, more willing to grant variances, and more respectful of state and local regulations. Margaret Anderson resigned from the board in May. The official reason was that she was pursuing other commitments, but everyone knew she had been forced out. Several homeowners had started circulating a petition to recall the entire board, and Margaret had become the face of everything people disliked about HOA overreach. Rather than face a humiliating recall vote, she resigned and moved out of the neighborhood within 2 months. The new board president was a guy named Kevin Morris who lived a few streets over. He was younger than Margaret, worked in IT, and seemed genuinely interested in being reasonable rather than tyrannical. At his first board meeting, he proposed changes to the covenant enforcement process, including a mandatory review by an attorney before any fine over $200 could be issued. He also suggested creating a variance committee to handle requests for exceptions to aesthetic rules, particularly when safety or regulatory requirements were involved. The changes passed unanimously. The Willow Creek HOA was still an HOA, still concerned about property values and neighborhood aesthetics, but it was no longer a fiefdom run by someone more interested in power than common sense. Life returned to normal over the summer. Emma started crawling, then pulling herself up on furniture, always on the verge of walking. Sarah went back to work part-time, and I settled back into my routine of work, family, and home maintenance. The propane tank sat behind its decorative screen, quietly doing its job of feeding the backup generator. It was just another piece of house equipment, unremarkable and functional. The generator proved its worth that August when a severe thunderstorm knocked out power to half of Marietta. Our neighborhood went dark for 36 hours while the utility company worked to repair down lines. But our house stayed lit, the air conditioning kept running, and Emma's baby monitor never lost power. I stood in the driveway that first night, listening to the hum of the generator and watching our house glow while everything around us was black. It was a small moment of vindication, a reminder of why I had fought so hard. Several neighbors came over to charge their phones and get cold water. I didn't bring up the propane tank fight, but a few of them mentioned it anyway, sheepishly admitting they had thought I was being difficult at the time but now understood why it mattered. One guy, Tom Henderson, who had questioned me months earlier, actually apologized. "I didn't get it before," he said. "I thought you were just being stubborn about where your tank went. But having power right now, knowing your family is safe and comfortable, that's what this was really about." "Yeah," I said, "that's what it was always about." By September, the entire experience had receded into the background of our lives. It was a story we told at dinner parties, a cautionary tale about HOA overreach and the importance of standing up for yourself. Sarah liked to emphasize the dramatic moments, the courtroom showdown and Margaret's face when the judge ruled against her. I usually focused on the administrative details, the permits and regulations that had made victory possible. Emma would never remember any of it, of course. She would grow up in a house with reliable power, never knowing about the fight that had preserved that safety. That was fine with me. Some battles are worth fighting not for glory or recognition, but simply because they're right. The propane tank battle had been one of those. I learned a lot from the experience. I learned that HOA boards often count on homeowners being too tired, too busy, or too intimidated to fight back. They rely on the power imbalance, the threat of fines and legal fees, to force compliance even when they're wrong. I learned that documentation is everything, that keeping detailed records of permits, inspections, and communications can make the difference between winning and losing. Most importantly, I learned that state regulations exist for good reasons, and private organizations can't simply override them because they don't like how something looks. The whole situation could have been avoided if Margaret and the board had been willing to be reasonable from the start. If they had looked at my permits, talked to the inspector, and granted a simple variance, nobody would have wasted time or money on legal battles. But some people are more interested in being right than in being reasonable, and that's how situations spiral out of control. I kept in touch with Chen after the case closed. He sent me a holiday card in December with a handwritten note thanking me for trusting him with the case. He said it had become one of his favorite victories because it was so clearly a matter of right versus wrong, safety versus ego. He had used my case as an example in 3 other HOA disputes, successfully arguing that state permits override covenant restrictions in each one. 2 years later, I was at a neighborhood barbecue when someone new to the area asked about my backup generator. He was considering installing one and wanted advice. I walked him through the permit process, recommended contractors, and explained the safety requirements. When he asked about HOA approval, I told him to get his state permits first, make sure everything was properly documented, and then inform the HOA rather than asking permission. "But won't they give you trouble?" he asked. "They might try. But if you've got your permits in order, they can't do much. There's legal precedent now," I smiled. "Trust me, I know. The propane tank is still exactly where it was installed 5 years ago. The decorative screening has filled in nicely with mature plantings, making it even less visible than when it was first installed. The generator has kicked on during 3 major power outages since then, each time keeping my family safe and comfortable while neighbors scrambled with flashlights and spoiled food. The Willow Creek HOA still sends out occasional violation notices, usually about garbage cans left out too long or lawns that need mowing. But they're more careful now, more aware that homeowners have rights and that courts don't automatically side with HOA boards. The culture of petty tyranny that Margaret Anderson had cultivated is mostly gone, replaced by a more balanced approach that recognizes the need for rules without using them as weapons. I still live in the same house on Maple Drive. Sarah still jokes that we should move somewhere without an HOA, but we both know we probably won't. For all the frustration the HOA caused, the neighborhood is actually pretty nice. The schools are good, the location is convenient, and most of our neighbors are decent people just trying to live their lives. The propane tank saga became part of neighborhood lore, a story that gets passed around when people complain about HOA enforcement. I'm occasionally recognized at community events as the propane tank guy, which is simultaneously amusing and slightly embarrassing. But I don't mind being that guy if it means other homeowners feel empowered to stand up for themselves when the HOA is being unreasonable. Looking back, I wouldn't change how I handled things. Fighting the HOA was stressful, expensive, and socially awkward, but it was necessary. If I had backed down, I would have been forced to either remove my generator system entirely or violate state safety codes to satisfy Margaret Anderson's aesthetic preferences. Neither option was acceptable. Sometimes you have to fight, not because you want to, but because the alternative is worse. The legal bills were worth it. The social friction was worth it. The stress and lost sleep were worth it. Because at the end of the day, I protected my family's safety, established important legal precedent, and helped shift the culture in my neighborhood away from HOA tyranny toward reasonable governance. That's a victory worth celebrating, even if the celebration is quiet and personal. Emma is in kindergarten now, a bright energetic kid who loves school and has no idea that her dad once battled an HOA over a propane tank. When she's older, maybe I'll tell her the story. It's a good lesson about standing up for what's right, doing your homework, and not being intimidated by people who claim authority they don't actually have. Those are lessons that apply to a lot more than just HOA disputes. The backup generator sits quietly behind our house, connected to its properly permitted and legally protected propane tank. It's ready to kick on whenever the power fails, keeping the lights on and the refrigerator running and the heat flowing in winter. It's exactly what I wanted when I started this process. A simple piece of equipment to protect my family during emergencies. That it became the center of a 6-month legal battle and a $13,000 judgment against an overreaching HOA board is just evidence of how absurd suburban governance can sometimes be. But we won. The state permit overrode the HOA rules, exactly as it should have. Safety trumped aesthetics. Regulations trumped covenants, and one stubborn homeowner with documentation and a good lawyer proved that HOA boards aren't as powerful as they think they are. That's the real victory, and it's one that continues to benefit not just me, but every homeowner in Willow Creek who knows they don't have to automatically cave to unreasonable demands from the board. Kevin Morris, the new board president, actually thanked me once at a community meeting. He pulled me aside during the break and said that my lawsuit had been a wake-up call for the board and the neighborhood. It forced them to examine how they were operating and make changes that benefited everyone. The new variance process had been used dozens of times since it was implemented, allowing homeowners to make reasonable modifications to their properties without the drama and expense of legal battles. You probably saved the association from itself, Kevin said. Another few years of Margaret's approach, and we would have been dealing with lawsuits constantly. Your case showed us we needed to change course. I appreciated the acknowledgement, even if it came years too late to prevent the stress of the original fight. But late recognition is better than none, and knowing that something positive had come from my stubborn refusal to back down made the whole experience feel more worthwhile. As I write this, the propane tank outside continues to sit in its original location, protected by a court ruling that established important precedent in Georgia HOA law. It's a testament to the principle that regulatory authority exists for good reasons and can't be casually overridden by private organizations more concerned with appearances than safety. It's proof that homeowners can win when they're willing to fight, document everything, and stand firm on solid legal ground. The saga of the propane tank taught me that backing down in the face of unreasonable authority isn't always the path of least resistance. Sometimes fighting is actually easier in the long run, because giving in to unreasonable demands just invites more unreasonable demands. Margaret and her board counted on me being too intimidated or too tired to fight back. They were wrong, and that mistake cost them dearly. I hope this story helps someone else facing a similar situation. If your HOA is demanding you violate state regulations, ignore safety requirements, or remove legally permitted installations, know that you have options. Document everything. Get your permits in order. Find a lawyer who knows HOA law and isn't afraid to fight. And remember that HOA boards have less power than they claim. They can be challenged, they can be beaten, and sometimes they need to be beaten to remind them that they serve homeowners, not the other way around. The propane tank is still there, exactly where it should be. The generator still works perfectly. My family is still safe and protected during power outages. And the Willow Creek HOA learned an expensive lesson about the limits of their authority. That's how this story ends, with a victory for common sense, regulatory authority, and the principle that safety matters more than aesthetics. It's not a dramatic ending, but it's the right one, and sometimes that's enough.